December 1, 1763. It's not a day that you find in history books, but it is nonetheless a day that is very important in American history. Because on that day, a trial was held at the courthouse in Hanover County. That trial became known as the trial of the Parsons Cause. And the Parsons Cause trial pulled Patrick Henry from being an obscure 27-year-old attorney into the forefront of legal and political circles in Virginia. In order to understand the import of the Parsons Cause trial, a little background is in order. Two factors come into play. In 1763, in colonial Virginia, tobacco was a money supply. Promissory notes for different amounts of tobacco were used in exchange much in the way we use and exchange cash money today. Another factor was that all Virginians, like it or not, had to be members of the Church of England, and landowners were taxed to pay for the salary of the local parson of the Church of England. In 1696, Virginia's House of Burgesses, Virginia's legislature, passed a law saying that the parsons could be paid in promissory notes for tobacco. The House of Burgesses set the salary of those parsons at 16,000 pounds of tobacco per year. This system worked fairly well until the mid-1750s. And then two factors occurred that upset the system. One of those factors was that there were a growing number of religious dissenters in Virginia, including Hanover County. These religious dissenters did not want to be members of the Church of England, and they certainly did not want to pay taxes to support the local parson. And another factor was that in both 1755 and 1758, the tobacco crops due to drought were a disaster. And so naturally, as tobacco became more scarce, the price skyrocketed. And the Virginia House of Burgesses stepped in. It passed what was known as the Two-Penny Act. And the Two-Penny Act, an emergency measure, stated that the parsons could be paid in cash money instead of in tobacco at the rate of 2 pence per pound of tobacco. Well, the only problem is that the going rate of tobacco, the fair market value, was 6 pence per pound, not 2 pence per pound. And so the parsons felt that they were being shortchanged. Even though the royal governor, Francis Farquhar, had endorsed the Two-Penny Act, the parsons sent a delegation to England to complain about it. The delegation enlisted the aid of the Archbishop of Canterbury and the Bishop of London, and they met with first the King's Board of Trade and then the King's Privy Council. And through those bodies, they convinced King George to overturn the Two-Penny Act. The parsons then proceeded to bring lawsuits throughout Virginia to recover their back wages, the difference between what they had been paid under the Two-Penny Act and what they should have been paid according to the fair market value of the tobacco. One of the first of these parsons to bring a case was the Reverend James Maury. Reverend Maury was the parson of the Fredericksville Parish in Louisa County. But Reverend Maury did not want to bring his case in Louisa County because one of the collectors of the Fredericksville Parish levies, the taxes, was a man named Thomas Johnson. And Thomas Johnson was a political power in Louisa. So Maury felt that he would lose his case in Louisa because of Johnson's influence. So instead, he forum shopped and he brought his case in Hanover County. The first part of the trial, liability portion of the trial, was held in November of 1763. An attorney named Lewis represented the collectors of the parish levies, the taxes, at that time. Reverend Maury prevailed. The court ruled in November of 1763 that Maury was indeed due damages for back wages. And then the court set a second date for the second part of the trial, December 1st, 1763. That is what we would refer to as the damages portion of the trial. That is where the court was to determine how much damages Reverend Maury was due. Well, Attorney Lewis withdrew from this seemingly hopeless case, and the tax collectors then hired a young attorney, 27-year-old Patrick Henry from Hanover County, to represent them. Henry had been practicing law for 3 years at this point. He had done moderately well as a country attorney. He was making a living, but he had no spectacular cases, no noteworthy pronouncements that would make him even a footnote in history at this point. Nonetheless, after Lewis dropped the case, the tax collectors turned to the local attorney, the young Patrick Henry, to be their representative. So we come to December 1763. It's important to briefly recall who the players are in this trial. You have plaintiff, the Reverend James Maury. In addition to being a member of the clergy, he was a well-known educator. His most famous pupil was a gentleman named Thomas Jefferson. Maury at one point had a school in Albemarle County, and he was a pioneer in stressing the importance of the teaching of geography in education. The two defendants of the case, Thomas Johnson, who we previously mentioned, and another gentleman named Tarleton Brown. They were residents of Lisa County, and they were the tax collectors of the Fredericksville Parish levy. The chief judge of the case was a man named Colonel John Henry. You will notice the last name. John Henry was Patrick Henry's father. You may think that's strange that a judge could be related to one of the attorneys in the case, but you have to remember the context of the time. The mindset was that gentlemen could set aside their personal biases and rule in an honorable manner fair to both parties. So Colonel John Henry was the chief magistrate. The sheriff in the case was a man named Thompkins. The sheriff played an important role in those days. The sheriff was the one who would choose a jury. Sheriff Thompkins picked a number of known religious dissenters to be on this jury. And surely Thompkins would have known about that. The clerk of the court was a man named William Pollard. Pollard was the clerk of the Hanover Court from 1740 to 1781. The plaintiff in the case, Reverend Maury, would call two witnesses during the case. One was a fellow named William McDowell, who was a local tobacco merchant, and the other was also a tobacco merchant, a man named Samuel Gist. Gist is an interesting character. Gist was born in Scotland. He moved to America as an indentured servant, and after the man to which he was in service passed away, he married the man's widow and thus became fairly wealthy as a result. He opposed the revolution and he moved to England in 1776. Prior to doing so, he was a partner with George Washington and others in the Great Dismal Swamp Company. And once he removed to England, he engaged in a number of ventures, including becoming one of the founders of what became known as Lloyd's of London. It's a very interesting character. Reverend Maury's attorney was a man named Peter Lyons. Peter Lyons was one of the foremost attorneys in Virginia at that time. And of course, we have Patrick Henry, age 27, and as I mentioned, an attorney for 3 years who had not particularly distinguished himself prior to this point. Also in attendance were about 20 other parsons. They had come from around Virginia to see what was going to happen in Maury's case, because what happened in Maury's case would have an impact on their cases when their cases came to trial. As the court opened, Attorney Lyons objected to the composition of the jury. And Lyons said, when making his selection, the sheriff passed through a room of quality gentlemen and out onto the courthouse green among the vulgar herd. He wanted a new jury. The judge overruled his objection. Lyons then called the two witnesses, McDowell and Gist. Both established that the fair value of tobacco was 6 pence per pound, not 2 pence per pound, and they established the amount that Maury was owed in back pay. Henry called no witnesses, but he did present evidence in the form of a receipt that showed the amount that Maury had been paid under the Two-Penny Act. It was then time for Lyons' closing argument. Lyons went through the history of the Two-Penny Act and the fact that the had declared it to be null and void. He went through the evidence establishing what Maury was owed, and he should have stopped there. In fact, Lyons made two mistakes during this trial. First, he objected in front of the jury to the composition of the jury and called them the vulgar herd. Certainly, if a lawyer is going to try to convince a jury to rule in his favor, he should not be calling them names such as that. Lyons' second mistake was that he went on to praise the Parsons in attendance, both Maury and the other 20-some Parsons that were there. Lyons stated, "These are the very men who have united you in holy matrimony, who have christened your children, who have day by day ministered to your spiritual needs. They have sat at the bedside of your sick, have supported and comforted you in your days of sorrow, have stood at the grave with you and administered last rites to your loved ones." Lyons forgot his audience. Lyons forgot that there were a number of religious dissenters amongst the jury, and that the religious dissenters had no love for these parsons of the Church of England. It was then Henry's turn to give his closing argument. He started slowly, but then passion gripped him. Henry stated, "A king and those he rules share a solemn compact. In exchange for their obedience, a king must rule in a way that brings happiness to his subjects. But gentlemen, compacts must be obeyed by both parties. And I submit that for a sovereign to disallow such a wholesome law as the Two-Penny Act in such a manner is an instance of misrule and breaks the compact between a king and his subjects. It may even be called tyranny." At this, throughout the courthouse, there were cries of treason, treason. And we must, at this point, recognize how revolutionary, pun intended, this language was from Henry. The notion that a government was a conditional compact between a king and his subjects, and that a king would forfeit his right to their obedience if he broke his part of the compact, was indeed revolutionary thinking at the time. Henry, then seizing upon Lyons's argument about the zeal and benevolence of the clergy, stated the following: "Yes, we have heard a great deal about the benevolence and holy zeal of our reverend clergy, but how is that manifested? Do they manifest their zeal in the cause of religion and humanity by practicing the mild and benevolent precepts of the gospel of Jesus? Do they feed the hungry and clothe the naked? No, gentlemen. Instead of feeding the hungry and clothing the naked, these rapacious harpies would, were their powers equal to their will, snatch from the hearth of the honest parishioner his last hoe cake, from the widow and her orphan children last milk cow, the last bed, nay, the last blanket from the lying-in woman. Mr. Lyons speaks of their past sacrifices in pay. Yet I see nearly 24 here, to see what rewards their greed may harvest. I see Reverend Mr. Odom, whose foxhounds are credited with being the best in all of Virginia. Yes, he is indeed in need of damages. to keep 36 fine dogs and go a-hunting 3 times a week must indeed take much money. Reverend Mr. Dowd, has another ship arrived in Fredericksburg with a load of fine Madeira wine? Then you must need money to keep your famed cellars renewed. Oh, and do not think that I do not see you, Reverend Mr. Cumberland. Indeed, how could I miss you? Very bench beneath you groans from your weight. It must take a great deal of money to keep your table renewed. Do not be deceived, gentlemen of the jury. This is not an issue of a few pence per pound of tobacco. This is a case concerned with freedom. Freedom for Virginia to govern itself. Freedom to choose who shall minister to our spiritual needs. Freedom from tyranny in whatever form it may take. It is a law of nature that a people may make laws for their own safety and common good. Unless you wish to fashion the chains of bondage around your own necks, you must make an example, this plaintiff, for those who would dispute the rights of free men to make their own laws. Award damages as you must, but send a message to tyrants by rewarding only 1 penny in damages. The judge asked Attorney Lyons if he had rebuttal. Lyons said, "Indeed I do, sir." He praised Henry's oratory, but he said, "Like me, gentlemen, you must not be blind to your duty. Henry has uttered treasonous remarks against His Majesty King George, and let me say, no matter how well spoken, treason is still a crime. Henry speaks of a higher law. Gentlemen, what he seeks is some utopia outside any law. He chases a dream, gentlemen. A land without laws is a land of chaos, anarchy, and misery. He warns you not to place the chains of bondage around your necks. It does not warn you that he would instead have you place there the hangman's noose of lawlessness." The jury retired to consider its verdict. The jury considered that verdict for a total of 5 minutes. It came back into the courtroom and the judge asked the foreman, "Have you reached a verdict?" The foreman said, "Yes, we have. We find in favor of the plaintiff, the Reverend James Maury, and award damages in the amount of 1 penny. Henry was carried from the courtroom on the shoulders of the crowd. Henry's argument that day effectively ended the quest by the Parsons for damages. No other case were filed, and although the king had disallowed the 2 Penny Act, indeed it became the de facto law of the land. Think about that the next time you decide to put in your 2 cents worth. Now, what's the importance of this? What's the importance of the Parsons Cause trial? Well, as far as the general historical importance, this trial is pointed to as one of 3 instances that occurred in the early 1760s that showed that there's a revolutionary spirit in America. The other 2 instances were the writs of assistance that took place in 1760. In those writs, England began allowing customs officers to use general warrants to search private property where no reason or excuse was needed. The other incident occurred in 1758. It was known as the Bishop's Affair. Word spread that the Archbishop of Canterbury and the Bishop of London were plotting to plant bishops in America in all of the colonies. Puritans in Massachusetts in particular were upset about this, and even Virginia Anglicans were alarmed because the church hierarchy had a reputation for corruption. And the Parsons Cause was joined with the writs of assistance and with the Bishop's Affair, one of the 3 instances in the early part of the period from late 50s to 1760s that showed that there was indeed a revolutionary spirit within the people of America. But perhaps the most important aspect of the Parsons Cause trial is what it did for Patrick Henry himself. As mentioned earlier, Patrick Henry at this point was 27 years old. He had been an attorney for a mere 3 years. He had not distinguished himself. He had made a living, and that was it. But upon arguing the Parsons Cause trial, Henry's name became known throughout Virginia. It thrust him into the legal and political circles in Virginia. Indeed, less than 2 years later, he was elected to the Virginia House of Burgesses. And he was elected to the Virginia House of Burgesses and started serving there in 1765, right at the time that England passed the Stamp Act. That enabled Henry to introduce into the House of Burgesses the Stamp Act resolves. They attacked Parliament's claim of authority to tax the colonies, and they hinted at resistance. Some of the resolves were passed and some were not, but yet all of the resolves that Henry introduced were published in newspapers up and down the colonies, and also published in newspapers in England. Indeed, in 1765, King George III learned the name of Patrick Henry. And although there's a historical debate whether Henry actually said this, legend at least has it that during the debate on the Stamp Act resolves, Henry said, Caesar had his Brutus, Charles I his Cromwell, and George III may profit by their example. And to cries of treason, treason, Henry said, if this be treason, make the most of it. Henry continued to serve in the House of Burgesses. He served also in the First and Second Continental Congresses. And of course, he served at the Second Virginia Convention in March 1775 at St. John's Church in Richmond. And Henry's words at the Second Virginia Convention were uttered in support of his resolutions to create a militia for the defense of the colony of Virginia. His resolutions passed at the Second Virginia Convention. That was a signal that Virginia was willing to fight. Up to that point, due to the intolerable acts, the port of Boston had been closed and blockaded, and trial by jury was suspended in Boston in many cases. Soldiers were quartered in private homes. And the concern was that the revolution, if it were in fact to be a war, would be limited to New England. But by the passage of Henry's resolutions at the Second Virginia Convention, that demonstrated that Virginia, the largest and richest colony, would enter the war, would defend itself, and would join with the other colonists. That was vitally important. After independence was declared, Henry went on to become first non-royal governor, and Henry served 5 terms as governor. Patrick Henry may very well have remained an obscure country attorney in Hanover County, that it was because of the Parsons Cause trial that Henry entered into the House of Burgesses, and you know the rest of the story. So, it's December 1st, 1763, a day you will not find in your history books, but a day that is vitally important to the history of this country, where the young, obscure country attorney, Patrick Henry, challenged the 2 most powerful entities in colonial Virginia, the king and the clergy. And now you know the story of the Parsons Cause.